Good evening.
Yes, over to boardroom.
Good evening, sir. With your permission, can we start the session? Good to Mukta for the introduction.
Very good evening to one and all gathered here. It is with immense joy and a deep sense of privilege that I rise to welcome you all to the 7th day of the 10-day online capacity building program on ADR, legal aid, and allied laws, a collaborative initiative by JSS Law College and Pro Bono India. Today's session is graced by a luminary in the realm of legal education, a scholar of rare intellect and remarkable humility, Dr. Hardik Parikh, our esteemed resource person for today. A man of scholarly brilliance and unwavering commitment to justice, Dr. Parikh holds a PhD in law and LLM in intellectual property rights and has also qualified the GSET. Currently serving as the head of training division and assistant professor of law at Gujarat National Law University, he also dons the mantle of faculty convener of the Legal Services Committee and the Pro Bono Club. Sir, we are indeed honored to have you here with us today to enlighten us on the powerful mechanism of public interest litigation, a tool that has time and again proven to be the voice of the voiceless and the shield of the marginalized. It is also my honor to extend a heartfelt welcome to Mr. Kalpesh Kumar Gupta, the visionary founder of Pro Bono India, whose unwavering commitment to bringing the gap between law and society continues to inspire many across the country. We are equally privileged to welcome the Chief Executive of JSS Law College, Professor K.S. Suresh, and our respected Principal, Dr. Vani Shri, in their absentia. A warm welcome is also due to our spirited and ever-dedicated faculty coordinator, Professor Asmatonisa Ji, whose tireless efforts and unshakable commitment have brought this program to life. And finally, a heartfelt welcome to all the participants, scholars, students, and legal enthusiasts who join us from across the nation. Your enthusiasm to learn, engage, and grow is what makes endeavors like these meaningful and impactful. With that, I once again welcome you all to what promises to be an intellectually stimulating and thought-provoking session. May today's discourse ignite minds and inspire action. Thank you.
Yeah, thank you so much for a warm words of introduction. I hope I'm audible and visible.
Yes, sir.
All right. So at the outset, I wish you all a very happy Dr. Babasaheb Ambedkar Jayanti. We are celebrating today in the memory of our wonderful drafter of Indian Constitution, and the topic which is also going to be relevant with respect of the most important and interesting development of the legal system of the nation, and that is the public interest litigation. So without taking much time, let us start a interesting discussion with respect of the jurisprudence. I always am very much eager to know that who are the participants, as I may ask the Kalpesh Kumar Gupta sir. Generally, the audience is a mixed group of students, professionals, faculty members also, as it is a limited interaction because the screen is not allowing us to interact with each other. Would definitely greet everyone again for your dedication and continuously attending the sessions, which are even organized on the holidays also. So best wishes to every one of you. And beginning the session, we are always aware about the mechanism of getting justice through various court system in our country. Now, when we talk about the system of justice, we always have a wonderful pillars of democracy in our mind. We always take reference of this all pillars. So we say that the entire constitutional mechanism is divided wonderfully among three broad categories, where we talk about legislature for lawmaking body, executives for law implementing body, and judiciary, where there is a issue with respect of interpretation of law, is with respect of enforcement of law, or with respect of non-fulfillment of the provisions of Article 13 of Indian Constitution, that is the pre-constitutional laws, post-constitutional law, and in its tussle with respect of the rights of the people. And therefore, this all rules are coming into picture. Now, here there are 2-3 interesting things which we are always keeping in our mind. The discussion about the pillars of democracy and role of judiciary, because what we are discussing today has a great connection with the judicial wing of the Indian Constitution. We are always focusing about this because we say that entire world, Indian judiciary has created a particular record with respect of generation of the system of public interest litigation, where you are bypassing the established norms or established system of Indian Constitution when we go for a particular justice and allowing any public spirited person. Now, there are multiple issues, queries, and even though you see when you read the social media with respect of the legal aspect, almost on the only alternative day, we get the news item with respect of the petitions filed before the High Courts or Supreme Court of India, and that too with respect of the multiple subject matter. Now, here we remember Lord Denning, who have a wonderful sentence that is, the power tends to corrupt and absolute power corrupts absolutely. I'm sure that all law students would definitely be aware about this. And in case you are listening to this kind of the sentences first time, you can take a note of that. It is very well said, power tends to corrupt and absolute power corrupts absolutely. That means we always go with the particular presumption that whenever there's a powerful body, the corruption, that not in a literary meaning, the corruption with respect of the monetary aspect is concerned. It is rather than dealing with the abuse of power or to interpret the rules for their own purpose, for their own desire, or for their own ease, which may result into injustice with the people. So when these aspects are happening, we always say legislature, one of the most powerful body who have lot of powers of enactment of the law, repealment of the law, also at the central as well as state levels, where we talk about executives, which is again a powerful body with respect of enforcement of legislation, that whatever laws have been enacted by the government, by the different kind of the institution, as required to be executed. What if there will be a clash? What if there will be a tussle between these two bodies and the public? Whether do we have any recourse to go and to ask the justice? And therefore, we have the system of judiciary where we start with the lower courts or subordinate courts, by which you can go to appeal to the high courts. And then in case when you are done with this, all the things, you are approaching the Supreme Court. Now, with due respect, the journey from lower court to higher at apex court would be a very long and many years will pass. So there are instances considering the population of the nation, considering the so many matters, litigations and pendency which are before the various courts. What if in case of the justice is not given on time? And with this all aspects, the concept of public interest litigation have emerged. So generally speaking, when we talk about the public interest litigation, we say it's a litigation which is filed in court of law for protection of the public interest. Now, what is meaning of the public interest? That word is interpreted many times. We are trying to judge, we are trying to touch this portion again and again. And this public interest ideas will be relating to pollution, or it may be terrorism, it may be road safety, it may be constitutional hazard, constructional hazards, or many matter, which is including the interest of the public at large, which is affected with the same kind of problem. So rather going individually in the court, you are always taking the help of the public interest litigation. Interesting thing is PIL is not defined in any statute or any act. Obviously, till the time Supreme Court rules were not there. After 2010, we are finding a lot of development with respect of every high court coming with the rules for public interest litigation, how to draft, what to be added, what should be not connected with the public interest litigation, which petition shall not be entertained. These all things have started after 2010, but before that it was not defined. But it is completely judicial interpretation with respect of the matters which are considered to be the urgent and including the public interest also. For the students who may be new for the topic, or even though you might have a little bit knowledge about that, we always say public interest litigation, we say it's a relaxation of rule of locus standi, okay, and judicial activism. These two things are very interesting. Obviously, in a higher studies, they are always discussed, and we interpret as a law student with this respect rule. Now, what do we mean by rule of locus standi? It's very well said that in case you have any problem, in case you are facing any violation of any right issue, or you are a person affected by virtue of any implementation of law, non-implementation of the law, or any enforcement of law, you are allowed to go to court. But what if there are multiple people and all of them, if select to go to court, there will be again a question of the overcrowding of the court, multiple litigations, multiplicity of litigation. In that case, the judicial activism comes into picture, and therefore we have wonderful concept of the public interest litigation. And therefore, it has been mentioned by Justice Krishna Iyer in the one very well-known case, Fertilizer Corporation, Kamgar Union versus Union of India. The law should not be a closed shop, else system may crumble under the burden of its own insensitivity. We always say, and all the law students who are attending the session here, I always identified them as a soldiers of justice. We have very high regards, and we can call them soldiers of justice. Why we call them soldiers of justice? Because here there is something interesting to observe. Considering the other avenues or other areas of practice where you talk about the students of medical, students of engineering, students of arts, humanities, commerce, the law student have something advanced or something extra in nature. You get opportunity to extend justice to the people, and only the lawyer have a right to approach to the court by virtue of appearing in front of the court and claiming the rights for the people who may be weaker section, who may be vulnerable, and many more time. So entire legal system is there, but unfortunately we see many times that because of the ignorance, illiteracy, or non-having proper idea with respect of the justice delivery system, sometimes injustice are also considered to be okay and absolutely acceptable in many questions. We are aware, and in case we just keep our eyes and ears open, we can see around that many times it happens with respect of the tenancy and landlord manner, with respect of the overcharging of the money, and many more. The society, you will find out that there are many examples where the injustice is visible, but because person is unable to find out the option, he will not be able to go. Now coming to the second layer, fine, if the person who is actually victim of injustice is approaching to go to the court, but what if the entire system is only for the selected people who are completely even coming from the XYZ background or who are having XYZ knowledge, they can only go to the court and get justice. So again, their awareness about law will also not be able to help them. And therefore, the observation made by Justice Krishna is becoming very important, that law should not be a closed room, otherwise it will be insensitivity also. In SP Gupta case also, the concept of public injury has been evolved by Justice Bhagwati, when it is mentioned that any public spirited person, when you are approaching the court for redressing the public injury, which may be relating to environment, which may be relating to human rights, which may be relating to administration of justice, or any arbitrary action, which I told you in the beginning, that power tends to corrupt, the arbitrariness of the executive, arbitrariness of the government, investigation of the cases involving public occupying or high public cases, these all issues would definitely require to be brought attention. Otherwise, whenever we talk about the democratic system, one of the important concept and important aspect of the democratic system comes with the principles of natural justice and well-established network of the courts. In case these two aspects are not satisfied, then it is not taking too much time to convert the anarchy into the society. And obviously, when the people would not be able to trust anybody, then we can see that in many cases, what highest actions are taken by the group of people, and then ultimately laws and order is always getting compromised. And therefore, we always believe and we always say that justice delivery system, the court system, should always stand strong in order to assure everyone that don't worry, in case any wrong thing happens with you, there is a system which will help you. And therefore, these concepts have been emerged with respect of that. The principle of locus standi, which I told you, is available with respect of one interesting case. There is a Just by Motibai Desai versus Roshan Kumar, 1976 case, in which the principles or traditional principle of locus standi are based on the theory that rights and remedies are correlative, and therefore only person whose own right is jeopardized is entitled to seek a remedy. Okay, so now what are the particular rules with respect of that? Generally, traditionally, this is the concept. Then only he can take resource to the jurisdiction of the court whose own legal rights of the person or property are directly and substantially injured. This is number one. When a person is suffering along with other members of the public by administrative action, he cannot challenge the action in question unless he can show some special injury to himself over and above the others have suffered. And then when a person is challenging an administrative action, is a total stranger, the court will not ordinarily entertain his petition. So these are the important points and important issues with respect of multiple aspect of the rule of locus standi. But in country like India, when we are strictly going to observe the rule of locus standi, there are multiple challenges and obstacles. The obstacles are in form of the poverty, ignorance, illiteracy, fear also. We have seen many times that there is a fear among the people that what if I will go to court and if any judgment will be passed against the people against whom I have filed a complaint, whether I will be safe, whether I will be able to stay properly in with my family. And this kind of rights are ultimately closing the doors of the court technical. And when the doors of the courts are closed, then we see the result would be something unimaginable, and therefore continuous suffering would be expected, and then it is absolutely against the principles of the democratic justice. And therefore, we have the concept of locus standi. And therefore, we say in a beginning that when we say principles of locus standi has been liberalized, has been expanded by the people, what does it mean? These are the reasons that poverty, ignorance, lack of legal knowledge, obviously, you cannot expect only the person who is victim of the injustice would come to the court. Let other person who is public spirited without any personal bias or personal gain approach the court, and court will listen to them. Number two, and very important, is High Court of Litigation. Even I'm sure that in a previous discussions, and when you talk about ADR, when you talk about the other alternative dispute resolution system, High Cost of Litigation is coming as a picture, and we feel very really sad where the high amount of litigation, including the court fees, including the advocate charges, including the different kind of the charges connected with the legal system would be there. So obviously, when we can see the personally, because working with the Legal Services Committee and Pro Bono Club at GNLU, we come across many cases where just a very simple matter is getting extended because of the high cost of litigation included, and then person is unable to afford the kind of thing. So that is again becoming a kind of a system where you are unable to give justice. Democratization of justice, redressal of the public injuries, and avoiding plurality of litigation. This is also one of the important aspects, because we say that generally you are always writing when you are drafting a petition that I have not filed any other petition with respect of the same ground or same matter or same reason before this court or any other court. Now there is a question why you write down this, because generally we believe that court should listen or hear only the latest petition and only the petition which is there, which is enforceable. It should not happen that the judgment is given to the existing petition and other petitions are pending. Now, when you talk about the injury to the public at large, it may be relating to environmental hazard. Now, imagine that 1,000 people or 1 lakh people are suffering problem, and if everyone is coming to the court, then the overburden of the petitions, obviously wastage of the resources would definitely be there, and therefore it is expected to be very reasonable that let us extend the rule of locus standi and let the person come on behalf of everyone. And finally, curbing executive access and ensuring the responsible government is also one of the reasons that what we mean by them. Whenever we talk about the executive actions and government, we always consider the role of the government for the protection of the people and to save them from multiple hazards. But when these things are come somewhere in unmatched, this kind of things are available. Now, generally, when you talk about the judicial process, I told you earlier that it is a judicial activism. Indian judiciary is known for many important aspects. And one of the most important aspects which I told you is it's a only judiciary in the world has come out with the system of judicial activism, where even though there is no any person who is suffering the problem is able to approach to the court, they can come. Now, generally, this is the entire spectrum of the public interest litigation within the judicial process. So when you talk about the judicial process, we bifurcate generally for easy understanding into 3 broad categories. One is judicial activism, one is judicial review, and one is judicial self-restraint. Now, when you say judicial activism, entire PIL is part of that, where judiciary is actively working and actively functioning in absence of any law, and then passing the resolution, passing the judgment, which are becoming binding to the class and to the society, unless and until the legal action is taken by the parliament or legislative assembly and to come out with the case. So that's a judicial activism. Second is judicial review also. Many aspects are coming under judicial review, and as we are aware, the judicial review is again bifurcated into 3 broad categories: judicial review of legislative actions, judicial review of executive actions, and judicial review of judicial actions. So legislative actions, you mean that when the law is passed, but then you are challenging the law, because recently you might have seen that when Parliament has come out with the legislations, the petitions are filed before the High Court and Supreme Court of India considering this law is unconstitutional, considering the law has violation of this provisions of Indian Constitution. So that is always supported to the judicial review. So judicial review of legislative action comes here. Executive actions, whenever actions are taken by the government in order to protect the people or in order to failing to protect the people, judicial review is always there. And whenever you are challenging the judgments of the lower court before the higher court, judicial review of the judicial action comes into picture. So these are the three broad categories of the judicial review. At the same time, you will see in some of the cases of the public interest litigation, there is a concept of the judicial self-restraint also. Now, for the students who are new, you can always keep in mind that it is always not advisable, because generally we say we have parliamentary democracy, not judicial democracy. When you see the salient features of Indian Constitution, we go with the concept that we have parliamentary democracy. We, the people, have got a power to elect the government, and that government is actually representing us whenever any legislation is passed or any legal actions are taken and the laws are actually enacted or repealed in the parliament. So technically, lawmaking should be the task of the parliament. But when the over approaching judgment courts are coming into picture, then in many cases courts are refraining, that we doubt that in case if will be passed any order with respect of that, the concept of democracy will not be satisfied. And therefore, there are n number of cases where judiciary has refrained to entertain the matter, and then matter has been left on the discretion of the parliament, which are policy matter. So these are the cases when you see judicial self-restraint come into picture. So these are the broad view of the judicial process. So I request that people who are learning this thing first time, that in case you want to go deep dive into the concept of PIL, you can read a lot about that. This is the so interesting topic with respect of writing papers, commentaries, and many more things which are going to be helpful to you, as we are not able to discuss all the thing in detail. But this is the broad outcome of that. Now, as we say, what is judicial activism? We have heard that PIL is a judicial activism portion. It's a proactive role played by the judiciary. Now, why it is called proactive role? You simply take example of the Vishakha case, where the working women at the workplace is not having any protection by the enacted provisions of the law. The judiciary is reading the international law and then giving the judgment that now onwards we are fixing the duty of the employer, which is not written anywhere till the time. So 1997 onwards, a proactive role is played by the judiciary for ensuring right and liberty of the citizens are protected. Now, why we say rights and liberties? Because obviously in a democracy, when we have assured the fundamental rights of the people, it should be always a duty of the courts to see that they are not encroached upon. And therefore, they are not hesitating to take the activism into consideration. The courts are moving beyond the formal role of mere adjudicator of disputes and become a player in the system of the country, laying down the principles and guidelines that executive must carry out. So this is what I told you, that earlier they're going and judicial review principles are used, and one more step is going forward by making the active provisions and making the law. So this is how judicial activism come in picture. So when we talk about the root of PL, it is relating to justice. As we have seen our preamble, the social, economical, and political justice is highlighted. When we talk about the social justice, most of the PL cases are rotating around the concept of the social justice, where society at a large is suffering a huge problem because of any kind of injustice created by the government officers or by the mass of people, by the private companies or private people who are not able to be governed by the government. In this all cases, this all social justice concept is highlighted, and then public interest litigation come into picture. Now, there are a few interesting cases which every one of us have to keep in mind when you read about the public interest litigation. We're starting with Husainara Khatun case. Obviously, time is very limited, so we are not going in a detail. But when there is an inhuman conditions of prisoners, where more than 40,000 prisoners are under trial, the petition, when it is filed before the court of law, it is considered the right to speedy justice is also fundamental right. Now, see, these are the things which are never written in Constitution of India, and it is not possible also. So when you read Article 21, when you read Article 19, when you read Article 20, the broad principles are mentioned. Article 21, no person shall be deprived of his right to life and liberty except according to procedure established by law. So when these words are written, now right to life and liberty is compromised when the people goes under trial. So this is a wonderful case of interpretation also. The students who are learning interpretation of statute, they are also going to be understanding this also, that how interpretation is given to the particular principle. So right to speedy justice is also fundamental right, and therefore courts are duty bound. Government is duty bound to make an necessary arrangement so that speedy justice can be there. The classic example of the public interest litigation is Sunil Batra versus Delhi administration case, where a simple letter written from the court of law, from the prison, is treated as a particular petition. So from Tihar jail, when petitioner has written a letter to the judge of the Supreme Court of India, that's a poor living condition of the inmates in the jail, and there are brutal assault and torture by the head warden. This letter is also converted. It's a very era where the formal jurisprudence of PIL was not there. But yes, the letter is simply considered as a public interest litigation by the court, and judgment has been given that after issuing the notice, multiple layers of administrative indirections are passed, and they have made sure that you are not going to violate the fundamental rights of the people who are in prisoner. Similarly, in case of the SP Gupta, it was held that any member of the public or social action group which are acting bona fide can invoke this jurisdiction under 226 or 32, which is for seeking the redressal against the violation of the constitutional right. So two rights are always considered constitutional rights or the fundamental right, which are considered to be the highest. And in case the enforcement of the public duties are not done by the executive action, or there is a word misdeed resulted into public injury, then it is becoming a fire case. So these are the primitive and very important cases which are been considered to be the milestone cases for the public interest litigation. Even in 2005, D.K. Parikh versus Union of India case, it has been held by the court that a true PIL is one which is selfless citizen having no personal motive of any kind except either compassion for the weak and disabled or deep concern for stopping serious public injury, approaches the court for either for the following purpose. It may be for enforcement of the fundamental right, for those who genuinely do not have adequate means, and preventing annulling executive acts and omission, violation of the constitution or law resulting into substantial injury of the public interest. So these are the cases where court has come out with the multiple observations and allowing the petitions. In case of R.S. Bains versus State of Punjab in 1996, Punjab and Haryana High Court held it that the court would allow litigation in public interest if it is found that impugn action is violative of any of the rights enshrined in Part 3 of Indian Constitution, means it is going against the fundamental right, and action complaint is palpably illegal or malified and affect the group of persons who are not in a position to protect their own interests. So as I told you, that power dynamism and the idea that power should be used for the welfare of the people, when this is called to be tilted, it is presumed to be misinterpreted, then the role of courts are coming into picture. Now coming to the public interest litigation practical aspect, as we all know that the public interest litigation is part of the writ jurisdiction. Now writ jurisdiction in Constitution of India is available in two articles. One is Article 32, where you can approach Supreme Court of India for seeking remedy for violation of the fundamental right. And the same writ jurisdiction is available to various high courts, where Article 226 can be used for seeking the remedy in case of the fundamental right violation or other legal right violation. For the friends who are new to the legal profession, you can keep in mind that powers of the High Court are wider in terms of the considering the Supreme Court of India's power. Why? Because Supreme Court has power to entertain the petition for Article 32, under Article 32 for the fundamental right violation only. But when you see power of the High Court, you can also go to the High Court under the Article 226 for fundamental right violation as well as the other legal right violation also. So again, I will request that you can keep in mind the rights into consideration, the broad category of human rights, then second category of the legal rights, then third category of the constitutional rights, and then fourth category is the fundamental right. So fundamental right, very limited rights, but very powerful rights enforceable by Supreme Court of India, and then constitutional rights, legal rights, again followed or possible by the high courts also. So in both the spaces, public interest litigation can be filed. Whenever you learn about the practical aspect of the fundamental rights or practical aspect of the public interest litigation, which is very important to keep in mind the classification of the fundamental right and also the interpretation which has been done by the courts in a previous judgment. Because also here the rule of precedent is available. I have put some of the important instruction here and important provisions here in which you might be aware that Article Part 3 of Indian Constitution, which is including Article 12 to 35, you can divide into two broad categories. Article 12 and 13 goes with the classification of definition. And then main fundamental rights are starting from Article 14 to 35. So when you talk about the state, why it is important to know about the state and to know about the law? It is important because state and law are very important, right? Because in a public interest litigation, when you are challenging the law or challenging the action, this action would definitely by any of the law. So there are examples have been given. There would be ordinances, there would be order. So here it is important for us to understand that actually whatever you are challenging, the action, whether action is through any kind of law, in this case, Article 13 comes to the rescue. The Article 13, 1 and 2 is also becoming very important, where the state is instructed not to make any law which is violative of any part of our any fundamental rights, which is part 3 of Indian Constitution, and any law is made, it is considered to be the void. And then the fundamental rights are there. So not speaking much about that, but these categories are required to be kept in mind whenever you learn about the fundamental rights, because it is very interesting. I'm showing you one interesting drafted public interest litigation. So whenever you learn the drafting, because theoretical aspect is very limited, you can always learn or read the cases, but main task is coming that how you want to approach the court, what precaution you need to make, and what are the guiding principles when you are drafting the public interest litigation. So these two things we are going to have it. So right, equality, freedom, right against exploitation, religion, culture, education, right to constitutional remedies. This all right you can keep in mind. When you talk about freedom, the 6 freedoms which are enshrined in Indian Constitution, you keep in mind. Article 21, which is giving right to life and liberty. It is important to know that this all rights which have been available on your screen are included into Article 21. And the reason behind this is a petition which is filed by the various advocates, various public spirited person time to time. And this all is also now part of the right to life. So as you see, right to life with dignity, right to livelihood, right to education, privacy, right to travel abroad, right to speedy trial, clean environment, food, health, right to get free legal aid, right to get against inhuman treatment, or even right against sexual exploitation at the workplace. These all rights have been identified by the courts as a part of the right to life also, and then corresponding provisions are available. Also, you have to keep in mind the writ jurisdiction also, what writ can be filed at what cases. There are 5 writs we are finding in 32 also, and same in 226 also. So habeas corpus, mandamus, prohibition, certiorari, quo warranto. Quickly, you can see, keep in mind that in case of habeas corpus, when there is a body or the person who is arrested or detention by the court and you are unable to find out the whereabouts, you are going before the court under 32 and habeas corpus. Mandamus comes where any government or quasi-judicial body is there where actions are taken or actions are not taken, and you want to approach the court for positive action or as the same time abstinence. But prohibition and quo warranto comes in case of the quasi-judicial authority only. You might be aware, but just because in writ petition, whenever you are filing public interest litigation, you also pray. By virtue of the prayer, you are making the prayer to the court. So prohibition certiorari comes into picture when there is a quasi-judicial authority and either you want to quash the instruction or direction which has been passed, or you want the court to stay the proceedings. So in this case, prohibition certiorari is used, and quo warranto comes into picture when the right of equality is violated, when the person holding the public office is not suitable or the qualifications are not there. So in this way, the writ jurisdiction will be coming into picture. Now, what's the significance of PIL? Which it is important because it is giving a common people access to obtain legal recourse by the court. It is instrument of social change, we have seen, and I will give some more examples that how social change has been brought by public interest litigation. When you want to get justice accessible to poorer and marginalized people, again PIL become powerful weapon when the human rights enrich those who have been denied rights, the people who are denied rights. Also, you can see democratization, access of justice to all. Everyone is equally entitled to go to the court and to get justice. Judicial monitoring of state institution is also there. When you see the PILs which are filed for implementing certain guidelines by the court, the judicial interpretation monitoring comes into picture. So you can always get in black and white that how the particular law was enacted and what is implementation or level of the law. It is for implementing the concept of judicial review and then enhancing the public depiction or participation in judicial review. So these all are becoming the important aspect of the public interest litigation. Now, this is the list of successful PILs for all law students who are learning and going to appear in a paper. You can read this all important cases. In Husainara Khatun versus Home Secretary, speedy trial and equitable justice has been identified as a public interest litigation of 1980 case. Vishaka case, as I told you, and now it's, I think, in very popular because nowadays a POSH Act is there, Prevention of Sexual Harassment of the Woman at the Workplace Act, and now it has becoming mandatory for the institutions also to keep IC in action and also to report the functioning of the internal complaint committee or the local committee. In that case, the Vishaka case is becoming very binding. Permanent Katara case, where medical treatment should be considered to be the first in accident, that is also a result of the PL which has been filed. Sheila Barse versus State of Maharashtra case, where custodial violence against women in prisons and separate lockup should be there for women convicts has been identified as a right in case of the public interest litigation. The 2G spectrum judgment 2012, when allocation of spectrum was done in a wrong manner, the entire policy scrapping has also been with respect of the case. When you see the Bandhua Mukti Morcha case, where elimination of the child labor in India is considered to be the violation of the fundamental right. Then Olga Tellis versus Municipal Corporation Bombay, when right to livelihood has been identified as a fundamental right. Then DK Basu versus State of West Bengal, where the guidelines for arrest and detention, which we are learning together when you read Article 22 of Indian Constitution, that is becoming important. Then State of Madhya Pradesh versus Narmada Bachao Andolan, where the land is acquired, but then rehabilitation resettlement of displaced people is not done. Then the intervention of the court is making it mandatory. And this is the case where the new law, which is Right to Fair Compensation, Transparency in Land Acquisition, Rehabilitation, Resettlement Act, was not enacted. It is in 2013 that central legislation came, which is now making it mandatory to giving rehabilitation to the people in case of the land acquisition. Then Harshad Prabhari versus State of Gujarat, where protection of the identification of the HIV positive people is also made as a directive for the hospitals. Then Lakshmi versus Union of India, which is very popular case for acid attack victims and their protection. And you see that even the provisions have been added into Indian Penal Code and later on in Bharatiya Nyaya Sanhita. Then when this kind of heinous crimes are committed, you are defining them as a separate punishable action. Then multiple cases by the MC Mehta versus Union of India, where n number of petitions have been filed by MC Mehta for Taj pollution, for Ganga pollution, for vehicle pollution, for oleum gas leakage case, and many more. And Supreme Court has got a wonderful judgments which are putting the legal protection at the highest level comparing to the violation of the rights. Then Well-known Citizen Welfare Forum Union of India, where precautionary and polluter-based environmental jurisprudence is developed. I must say that environmental jurisprudence in our country is largely having a back by the public interest litigation, because when the principles were not evolved by the legislature, the court has come out and granted multiple principles, and that has the environmental hazards or that decrease the environmental hazards in our country. The Research Foundation for Science, Nanotechnology and Natural Resources, where import of the hazardous waste has been considered to be the actionable policy, has been drafted by the court in this case. The Dr. Vadera versus Union of India, where management of the solid waste, Yamuna pollution case, firecracker and knowledge case, and many more cases are there, which are successful public interest litigation. Now, till the time we have seen how it is working, it's a rule of locus standi, it is allowing the public spirited person to come. But there is an interesting thing also, that whenever any special window is created, we have seen that the abuse and misuse start immediately after that, right? Because when some door have been kept open for public and public spirited person, so who are unable to get justice, who are in a not possible to represent themselves into court of law, because generally we see the access of the court are also limited, because the courts and coming from the official area, rural area is very difficult. Now, in this case, what happened that some people started misusing public interest litigation. That has also been observed. So in 1970 onwards, in 1980s, when PIL was at the peak for development of the jurisprudence of the nation, afterward the misuse has been filed. What is the misuse? Some PILs are filed for publicity. Some PILs are filed for private interest. There is a political rivalry for any oblique motives. These are the examples where the publicity, we have seen that the people who are going to court and getting certain kind of the favorable order will become very popular. So is a public interest litigation is a tool for publicity? Is it for political rivalry where you are challenging always government's actions because you are part of the opposition party, and therefore even though something is done correct, you will challenge it and then you will be able to come into attention. So these things are always coming to picture, and therefore it was a high time for the court that some effort should be taken so that genuine people should be entertained and only serious petitioner or who are actually required to give justice should be entertained. In other words, we can see public interest litigation is that kind of thing. Suppose generally when a person is suffering from cold and cough or a fever, he would be waiting. He would be going for the cash counter first. He will get a case on his name. And then he will be paying certain amount of fees to the hospital. Then he will be sitting outside the doctor's room. And after when his turn will come, he will go to doctor and doctor will give you some medicine and then ultimately he will be able to go back to the home. But what if the person is in accident from the ambulance? If the person is brought to hospital, there is no need to wait at the counter. Directly, the person will be in operation theater and operation will be done. Article 32 and public interest litigations are treated in this way that there is a no requirement to spend your time into the local or lower courts because your injury is something very serious. And if it is not attended, then it will be a grave injustice to the person as well as the group of the people also. But then it should not happen that everyone who want to go directly for the operation theater will take the shelter of the ambulance and will unnecessarily sit into ambulance also. And therefore, this is actually a challenge for the court, and therefore, it has been held in many cases that PI should be not filed only by the clean hand, but also by clean heart and clean objective and clean motive also. And therefore, the courts came out with the observation where there was no specific uniform guidelines. In Supreme Court of India 2013 came with the guidelines of filing public interest litigation. Gujarat High Court also came in 2010, and later on every High Court, even Orissa High Court, Delhi High Court, every High Court has also come out with the guidelines that what should be treated in a public interest litigation. So now it's a time that I will show you the important aspect of the public interest litigation, and we will be able to see that what are the important guidelines of the public interest litigation. I will bring your attention to the guidelines and then we'll see the actually file public interest litigation in court of law. So you can see on the screen that is Supreme Court rules 2013, where the rule number 12 has been mentioned very clearly that in case you are filing a public interest litigation, these are the matters in which public interest litigation should be filed. So it can be a suo motu petition in pursuance of the order of the Chief Justice or Judge of the court, in pursuance of any order of the Chief Justice or a judge nominated by the Chief Justice on letter or representation. It may be by an order of the court to treat petition as a public interest petition and by representation of the petition in court. So these are the area which is going to be handled as a public interest litigation as per the Supreme Court of India rules. Now here, when petition is filed in clause D, if any petitioner is filing, these are the disclosure required. As we saw that public interest litigation would have certain kind of the risks, that it may be a personal in nature, it may be having an identification, or it may be sponsored. And therefore, these things are required to be disclosed in public interest litigation petition. So you have to disclose the full name, complete postal address, email address, phone number, proof regarding personal identification, occupation, and annual income, PAN number and national unique identity card number, if any. Then facts constituting the cause of action, the nature of the injury caused or likely to be caused to the public, nature and extent of the personal interest, if any, if the petitioner, details regarding any civil, criminal, or revenue litigation involving the petitioner or any other petitioners which has or could have been legal nexus with the issue involved in the public interest litigation, whether concerned government authority was moved for relief sought in the petition, and if so, what is the result, and file affidavit stating that there is no personal gain, private motive, or oblique reason in the filing public interest litigation. This thing has become important. Generally, we always see that public interest litigation should be moved at the last resort. Now, what I mean by last resort, generally, whenever there is a grievance, always petitioners are allowed to go to the various bodies who are entitled to take care about their grievance. It may be relating to environmental pollution, it may be relating to some labor law matter, policy matters, it may be relating to prisoners. Now, if without approaching them, if directly you are going to Supreme Court, then obviously it is required to be kept in mind that it is a court where multiple petitions are pending which are reaching there after years and years. And therefore, it is always mentioned that what actually happened when you approach the government authorities and whether they are failing to tackle your case or not. Sometimes right to information act is also becoming very powerful weapon when you are creating data for public interest litigation. The example of the various public interest litigation shows that the petitioners will always resort to the right to information act. They will file RTA applications, collect the data, and when the data is huge in nature, huge in number, where the grave non-performance is visible of the government, where the rights which is given to the people are not granted, and in this way you have only one option to go to the court, and therefore these all things are there. And there is also affidavit required, which is no personal gain. So these are the things. On the screen, you can see other rules also which are available with respect of the PL. You can see on the screen that these are the rules which I collected. These are the rules of Delhi High Court. About the PL, you can see the notification also. Every High Court has come out with the definition of PIL, what will be the public interest litigation shell, how the PL will be scrutinized, how the guidelines will be there, which court will take into consideration. So these rules are there. For your kind information, I will share these rules to Kalpesh sir. He will be circulating these all rules with you. You can always have a look to that. Now, when you talk about practicality, I always like one thing in my mind that generally when being a teacher, we go to class, we discuss with the students that have you read MC Mehta versus Union of India case where the Taj trapezium was identified, the yellowish color of the Taj was considered to be the objectionable, and then court granted relief to the petitioner by for shifting all the factories outside the Taj trapezium area. So when generally as a student of law, we read judgments only. But I always ask to my student that, do you want to know that what actually pleadings would have been made in petition, which would be so powerful that court would have relied on that and have given the judgment on that? That's a part of the legal drafting. In a fifth year or in the third year of the law, we are learning the drafting, pleading, conveyancing. And generally we take the templates. But the best mode to understand the drafting is learning actually filed petitions. And it is making all the difference. I also teach drafting to the students at GNLU. And we have certain examples that generally we collect the actually filed petitions, and we also take the respondents' response, what has been stated by that. And obviously with the help of certain advocates, alumni, it becomes very easy for us, because this is what bringing practical aspect into the classroom. Because otherwise judgments are all openly available. Now there are various websites also which are giving summary of the judgments, but then summary of the judgment is not able to help us when we are actually preparing for the legal practice. And therefore I always believe, and for a kind information, these are the various petitions which I have collected for. You can see number wise that there is a petition for gender equality, petition for elephant when the in a one of the national park in Assam where animals or elephants are meeting with the accidents with the train. There is a petition filed before the apex court to make a corridor. There is a petition for implementing law commission report for election matter, disabled friendly footpath, so that government offices would also be able to be accessed by the specially able people. Live streaming of the court proceedings, Rohingya refugees, targeted lynching, Yamuna River, firecrackers, and special bench. Even the petition was filed before the High Court in for odd even scheme which was launched in Delhi. These all are petitions which are available. I have collected few of the petition, and I will request that in case you want to learn about PL, you read this petition. I have brought one petition for you to just have a look to that. This is a small petition of 42 pages, which is filed for environmental aspect. You can see it is in Supreme Court of India, and something we'll study here. So when you are learning about the petition and practical aspect of the petition drafting, theoretical aspect is mostly covered and it is very easy. You will be able to get it. But I request that whenever you are actually drafting the petition, have a look to certain paragraphs, because the entire law study is 10% and drafting properly is a 90%. You can see you study all the laws, their substantive law, procedural law, what are the rights, what are the remedies. That is taking only 10% of your career. When the matters is actually arising and we are able to draft it and put it in front of the court or any body which is going to give justice, that is something more important. Unfortunately, because of multiple reasons, we are unable to spend more time. So I take this opportunity to request all the young lawyers that if possible, read practical drafts, read something important, and then you will be able to bring it. So here also you can see there's a petition filed by Goa Foundation, which is society registered for the society under Society Registration Act, having registered office at Goa. And this is petition with respect of illegal mining. So you see, it is represented through Dr. Claude Alvarez as a petitioner, and then it is against Union of India, Ministry of Environment and Forest, State of Goa, Ministry of Mines, and Indian Bureau of Mines and Goa State Pollution Control Board. Now, I will tell you something interesting here also. When you are drafting petition, you also see the legislative competence. You refer Article 246, Schedule 7 also, that whenever the petitions are filed, who is actually the authority to take actions about the particular topic which is part of the petition. Okay, so then you see whether it's a concurrent list subject, whether it is a state list subject or it's a union list subject. That also you say you take simultaneously, because court want all the people relevant to the petition for the subject matter can be called by virtue of issuing notice, because whenever the petition is admissible or admitted by the court, the notice is getting issued. So there is a one particular format you see. So here Union of India, whenever you are writing, it is always through Secretary of concerned ministry. It is not like that Union of India you are calling Prime Minister or President of the India, right? So this is what a very proper way of drafting the petition. Then State of Goa, that is through Chief Secretary, when you are going to call the responsible person for that. So that then Ministry of Mines, which is also through Secretary, New Delhi, Bureau of Indian Bureau of Mine. Now you see the topic of the petition. It has been mentioned that writ petition in PIL nature under Article 32 of the Indian Constitution in the interest of conservation of forest and ecology and environment due to damage caused by the rampant illegal mining of iron and manganese ore in the state of Goa, virtually leading to the extinction of the limited natural resources and contributing fragrant abuse and arbitrary exercise of the administrative power. So as we told, that public interest litigation for damage to the ecology, where people who may be forest dwellers, there are animals, there are people who are residing in the vicinity, and also the rights of the people to get livelihood, to get proper environment, this all is getting hampered. Then this petition has been filed before the court. So you are addressing the Honorable Chief Justice and the competent judges of the court, Supreme Court of India, and you see the main paragraph. I am just highlighting the main paragraph considering the positive of the time, because we have question answer session also. You see the important point that this petition is under the Constitution of India, Article 32, in form of the PIL being preferred before the Honorable Court for the wake of continuing illegal mining in the state of Goa in complete and flagrant violation of the statutory norms, which not only raises issue of serious concern about the adverse and irreparable damage caused to the ecology and degradation of environment in state, but also issue concerning transparency and accountability of the functioning of the government. And then area of the party. So here you are writing in a Supreme Court rule, we see that you should mention what is your credential. So it is a society registered under the Society Registration Act, having registered office at so-and-so place, who is representing. So you are writing the Dr. Claude Alvarez, who is Secretary of the Society, who is authorized to sign the petition. And the aim and object of the society is to protect the environment and assist in formulation of the law. What is your basic objective of the body who is representing the petition? Society is in furtherance of object has filed several public interest litigation toward protection of the forest, national parks, sanctuaries, coastal areas, mining violations, and enforcement of the environment impact assessment, notification, etc. Certificate and authority letter are filing along with the Wakalatnama. Respond number 1's credential, respond number 2's credential. Then you are writing about respond number 1, 2, 3. Now you are writing the facts. That what are the factual aspect? That is what a little bit lengthy. I am not reading that, but I am bringing your attention that this is how you are mentioning the facts. With all, you are putting annexures, which includes reports, certain news reports, right to information application. If you have got any report, then the administrative orders, the different actions taken by government, what are the objections raised, because whenever mining projects are there, there are necessary systems you are following in form of the environmental impact assessment, hearing of environmental impact assessment, objection raised by the people, then how you are dealing with the objection. This all documents are becoming important record also. So this all things in a detailed manner is always required to be mentioned. Then what are the other actions? This all things systematically you can see. Because of time is very less, we are going for the important aspect of the grounds and prayers. So when you see the prayer what has been prayer? The prayer has been mentioned to issue a writ of mandamus or any other appropriate read, order, or direction, directing in immediate steps to be initiated by the respondents to terminate all leases that are found to be involving illegal mining and mining in violation of the provision of the Forest Conservation Act and the environmental laws and other laws, to issue writ of mandamus or any other appropriate writ, order, or direction, directing that no mining operation including trading and transportation in respect of the mining leases shall take place unless all the statutory sanction, permission, and approvals are subsisting, to issue writ of mandamus or any other appropriate writ or order direction, directing action against all the violators involving either directly or indirectly in illegal mining, including those names in the report of Justice Shah Commission, including but not limited to under Article 21, read with Section 4.1 and 4.1a and 21.5 of MMDR Act 1957, read with Rules 24a of the Minerals Concession Rules, Section 45 of the Water Prevention and Control of the Pollution Act, and Section 37 and 39 of the Air Prevention and Control Act, provisions of the Indian Penal Code, to issue writ of mandamus and other appropriate action, directing recovery of illegal wealth accumulated through illegal mining and related activity, to issue writ of mandamus or other appropriate writ, order, and direction, directing that null and void retrospectively all renewals, leases, sub-leases granted, renewed in contravention of Rule 24a of the Mineral Concession Rules, to issue writ of mandamus or any appropriate writ to order respondent number 1 to 5 to repair, restore, and reveget the area in accordance with the establishment forestry practices in terms of the National Forest Policy, and to require all mining leases occupants relating to forest land and land covered by the trees, and to pay a fine and compensate in such repairs, restoration, and revegetation, to issue writ of mandamus or any other writ, order, or direction directing respond number 1, 2, and 3 to prohibit any mining activity or transportation already extracted or to dump rejection without following provision of the Indian Forest Act, and to issue writ of any other appropriate writ of direction for prosecution of the offenders or violators involving the case of pilferage of state revenue, offences, and illegalities committed in the mining activities in the state of Goa and convenient of the public servants, abetting and aiding the offence illegalities in the mining activities in state of Goa, and to grant any other relief, whatever granted. So this time PILs are getting filed. As I told you that it is one of the most important subject. Learning about PIL and getting rights enforced is one of the most interesting area of the practice, and all the law student must have the knowledge with respect of that, because the way the jurisprudence has developed in our country and many important judgments are there which are based on the petition, it is important to keep in mind. So this was small petition which was there, and we have seen a lot, some of the theory aspect, some of the practical aspect also, and you can always read. I have prepared this folder for the participants only. You can always have a look to this folder once it has been shared with you. So I hope that it is getting clear, because time was given till 8 o'clock to me. So I'm stopping here for interaction, and any question, query relating to subject we can entertain and we can discuss in case you have any questions or concern. Yes.
The participants can unmute and ask any questions that they have. You can also drop your questions in the chat box.
Okay, participant, I have, set the arrangement so you can unmute yourself. Any question, query, or thought, anything from your side.
So there's a question in the chat box. Is there any fee for filing a PIL?
There's a hello. Yes, Hardik, there is a question in the chat box. Is there any fees for filing PIL?
Yes, yes. It's applicable as per the High Court and Supreme Court rules. Generally, the 50 rupees to 100 rupees as per the High Court rules, the PIL fees are there. There is no special fee, but the way petition is always governed by the court fees, that court fees are required to be paid for the petition. It is as per the High Court and Supreme Court practice rules only.
Okay. Next question, can PIL be filed against the private company if public rights are affected?
That is very interesting thing. Whenever you see the writ petitions or jurisdiction, general writ petitions are entered in against the state government. So private parties at directly not part of the public interest litigation, because generally there is a state department. Yes, they can be joined as a as a respondent in case they are not fulfilling. But generally, when you are filing a petition, when the private companies are involved, you are always going to hold the concerned department liable, who are required to take action against the private parties. So, like suppose any private company is involved and there is a case about the company's matter, you're always going and taking the records and filing the normal complaint and actions before the company law or Ministry of Corporate Affairs. In case this grievance is not getting resorted, your petition is against the government or state under Article 12, and then it is getting enforced. So private parties directly not coming under the public interest litigation.
So we have another question. How can the judiciary adapt PIL
Yes,
mechanism?
yes. It's a very interesting question. How can the judiciary adapt the PL mechanism to address emerging issues like data privacy? Let me tell you that these mechanisms are already evolved. You see that the Puttaswamy judgment, when the Aadhaar case was there, afterwards many petitions have been part in which the judiciary has spoken about this, and therefore the Data Privacy Law, Data Protection Act came into picture. But some of the things like the practices by the multinational corporation with respect of the data, misuse of data, most of the time when we see that government has enacted the law, and after that if there is an enforcement of the law and there is a issue that there is a law is not properly enforced or there are still some lacuna, then again you can go and file the case. But again I'll tell you that it is a policy decision. So directly when the international institutions are concerned, the judiciary will always refrain from filing any instruction directly governing the government. Rather than it will be left on the policy issue of the court, and accordingly the data privacy, the law, Data Protection Act has come into picture. So it's again emerging issue for the matter also today we are dealt with.
Okay, any other question, query, participant from the boardroom? Couple of questions, then we'll close. Over to boardroom.
Thank you, sir. Sir, are there any subjects upon which PIL cannot be filed, even though it falls under Article 12?
Sorry, I could not. Can you repeat again, please? I could not listen. Yeah.
Sir, are there any subjects upon which a PIL cannot be entered in, even if it falls under Article 12?
So you want to see what exclusions are not there? Exclusions.
Yes, sir.
Yes, yes. In public interest litigation, as I show you, I would like to show it again. You can see on your screen. I will share it once again. So you can see in Supreme Court in 2010, when Supreme Court came out with the public interest litigation things, then the letters petitions are filed, but the subject matter has been mentioned that what will not be entertained as a public interest litigation. So here it has been mentioned the service matters, the matter relating to normal implementation of the law, the matter which are relating to landlord and tenant, or the matter which are part and parcel of the normal administrative actions are not part of the public interest litigation unless and until the actions have been taken. So I will be sharing the copy of PL rules with you, in which court itself has mentioned that these things shall not be considered as a public interest litigation.
Thank you, sir. Participants, are there any other questions?
So it's a most interesting subject. We don't know exactly the status of the students who are participating, but yes, it would be wonderful in case you get a practical face-to-face discussion and you draft or you get the any exercise to draft the public interest litigation. Obviously, There are many examples where court has rejected the PILs, court has entertained the PIL. In Gujarat, I will give example, which is recently in 2010. In Gujarat, there was a PIL in Gujarat High Court by one organization which is called Patni Pidit Purusho Ka Association. And the petition which was filed was that please save us from uh, the the laws which are made purely for the women. So there is a very, it's a very popular judgment, and ultimately the petition was requesting the court that grant any special remedy to the husband who are married and who are subject to brutalities and violence by the wives. And that petition was held to be bad in the law and wasting of the time, because court came out that when the laws have been made for women, they are for the vulnerable communities, and there are certain instances by which government enacted the law. So you cannot come to us directly to make this particular law specially kind of law for the male people or male group of people, and therefore it was rejected with the fine of 1 lakh rupees. This is available, you can search it. Some of the news items are also available. So we have to keep in mind whenever, because when we are going to practice, we become soldiers of justice. There are people who will come to you, many people will come to you, which is very easy, because generally it is difficult to go through proper channel. You go to local bodies, you go to High Court, and then you go to Supreme Court. So sometimes a law student should always have a sensitivity or as a idea that what should be considered to be the proper matter to go before the court and what should be discarded, and that will come with the constant practice. So my request and advice to all young law students is to read maximum things about the public interest litigation drafts, and to see what is observation of the court in many matters. That is always going to give us the helpful, and it is possible that if we are able to give justice to one person also by filing appropriate petition, which is very very reasonable, very required, like example we have seen, I think the very good satisfaction we get in our mind that yes, whatever law we have studied, it is actually implemented and we are able to get justice for the people. So my best wishes to all the people who have joined today, and I wish that you can learn this subject by heart and you can practice it, and you can definitely do wonders in your respective field whenever you are going to practice.
Thank you, sir. With that, I would like to hand over to Maria for the vote of thanks.
A very good evening to one and all. As we draw the curtains on today's enlightening session, it is my honor and privilege to deliver the vote of thanks on behalf of the organizing committee. First and foremost, our heartfelt gratitude goes to our distinguished resource person, Dr. Hardik Parikh. Sir, your engaging and insightful session on public interest litigation was truly a masterclass. Your lecture was not just an academic discourse, but a call to conscience. With clarity and depth, you walked us through the nuanced landscape of rich jurisdictions, unraveled the aspects and significance of public interest litigations, and offered keen insights into landmark public interest litigations that have transformed Indian jurisprudence. Your thoughtful analysis of the challenges faced by PILs and the relevant Supreme Court rules governing them added immense value to our understanding, sir. You have stirred our minds and hearts with your vast knowledge, practical insights, and unwavering passion for justice. We are truly grateful for your time, your thoughts, and your generosity in sharing your expertise with us. We also extend our sincere thanks to Mr. Kalpesh Gupta, the founder of Pro Bono India. Sir, your commitment to build a bridge between legal education and grassroots legal empowerment continues to inspire us. Thank you for being a constant pillar of support in this noble initiative. We extend our sincere appreciation to the Chief Executive of JSSLC, Professor K.S. Suresh, and our respected principal, Dr. Vanishri, in their absentia for their guidance, support, which has been an instrumental in smooth execution of this event. A special mention and sincere thanks to Professor Nagendra Murthy, Associate Professor of Law at JSS Law College and a valued member of our Legal Aid Clinic, for gracing the session with his virtual presence. A special note of thanks to our tireless faculty coordinator, Professor Asmatunnisa Ji, whose commitment and meticulous planning have been the foundation for this program's success. Ma'am, your behind-the-scene efforts deserve much recognition and gratitude. To all the participants, your enthusiastic involvement and thoughtful engagement have added immense value to today's session. Thank you for being such a vibrant part of this academic journey. Lastly, a word of appreciation for everyone working diligently behind the scenes, from the technical team to the student volunteers. Your silent contributions are the threads that hold this entire tapestry together. With that, I thank you all once again for being a part of today's session. Wishing you a very pleasant evening and looking forward to your continued presence in the sessions to come. Thank you.
Thank you very much, Dr. Hardik, and then we
Thank you
look
so
forward to seeing
much.
you
Good
again.
night and best wishes to everyone. Thank you.
Thank you. Thank you.